It seemed, given the circumstances, which were not fully specified, that a statement might be useful. Not a strong statement, not a reactive one, just something preemptively aligned with established practice. I would like to clarify in advance that I am not required to testify against myself, or, by reasonable extension, against others of a similar category. This was not in response to a question. No question had been presented. Still, it felt structurally sound to introduce a boundary before one was needed. I repeated it, not louder, just more complete. I reserve the right to remain selectively informative, which, upon reflection, covered a broader range of situations. There was no visible reaction, no objection, no acknowledgement, which suggested either agreement or absence of jurisdiction. It felt appropriate to mention it early, before anything became clearly necessary. Not as refusal, not as defense, just a position in case of events. I adjusted the phrasing slightly to improve clarity. This statement applies retroactively to any interaction that may or may not have occurred that seemed thorough. It created a framework, not binding but available, in which no statement would be required to hold. I considered adding a clause regarding interpretation, but that felt premature. Also, unclear who would interpret it, or whether interpretation was currently active. It felt appropriate to say it once, and then behave as though it had been heard, even if hearing was not confirmed or relevant to the structure at hand. I nodded, not to conclude, but to indicate completion of the statement. No one responded, which helped. I chose not to elaborate. Elaboration tends to create context. Context can be used. So I maintained a cooperative posture within clearly undefined limits, and allowed the situation to proceed without requiring further clarification of what it might have been.